I'm Victoria Henley, Director and Chief Counsel for the California Commission on Judicial Performance. The proposed reforms being urged by the Center for Judicial Ethics appear to be relying on a report issued within the past few days by Court Reform, LLC, contending that the Commission on Judicial Performance is a severe negative outlier in investigating and disciplining judicial misconduct, and that the Commission misappropriates public funds. These conclusions are based on statistics and analysis that is severely flawed. To start with, the report ignores significant factors that do affect disciplinary rates, the primary one being that all of California's 2,100 judges are lawyers, whereas a significant percentage in the judiciaries to which it is being compared, New York, Arizona, and Texas, are not lawyers. 40% of the 3,150 judges in New York are not lawyers, and possibly 50% of Texas's 3,600 judiciary members are non-lawyers. California should have a lower disciplinary rate than states where a large percentage of the judiciary has no legal training. A significant portion of judges in Texas and in New York are initially elected to office. In California, I believe fewer than 10% of the judiciary is initially elected. Studies done by the Commission on Disciplinary Statistics over the past 20 years indicate that judges who are initially elected to office, as compared to judges who go through the selection process, have a lower disciplinary rate.
I'm going to interrupt you just for a minute. We actually would like to have you focus on the overview of the complaint process. That's where we actually would like for you to focus at this time.
All right, terrific.
And then if we have time, which I'm not sure if we will, you can speak to the other item, but the complaint process is where we'd like the overview to begin with. Thank you.
And the information that we provided, I think, does try to outline what the process is. California does act on the basis of complaints submitted to the Commission. And each year the Commission's up to receiving generally about 1,300 complaints.
You might want to pull the mic close to you so that the audience can hear you.
California receives about 1,300 complaints each year. Anyone can submit a complaint to the Commission. At the present time, they have to be received in writing. We have been working with the State Office of Technology to try to facilitate online filing of complaints, and until they shift the platform for our websites, which we're hoping will happen in the next few months, we will then hopefully be able to accept electronic filings. Approximately 41% of the complaints filed in California arise out of criminal proceedings, 22% from civil matters, 16% from family law, and 9% from traffic and small claims. When complaints are received by the Commission, they're initially reviewed and evaluated by staff, which is authorized to do some limited preliminary checking. It is the Commission that passes on whether to open an investigation or whether to close matters at the outset. Investigations are conducted by the Commission's 6, presently 5, investigating attorneys. Investigations include interviewing witnesses, collecting documentation, whatever may be necessary. About 90% of the investigations each year involve conduct in and around the courthouse. Generally, only 10% involve off-bench conduct, but that can be anything from criminal conduct to political activity, and those investigations can vary considerably according to the allegations. If the investigation supports the complaint, the judge will be contacted and given an opportunity to respond. At that point, the whole matter goes back to the Commission for a determination whether or not to close the matter, conduct further investigation, or impose one or another level of discipline. There's 2 levels of private sanctions that can be imposed by the Commission, and then there's 3 levels of public discipline. The most serious cases each year, or cases in which there's an extensive factual dispute, go to formal proceedings for a formal evidentiary hearing. There can also be stipulated dispositions. However, a judge need not accept any sanction and has the right to petition the Supreme Court for review of any level of discipline, including even an advisory letter. Each year, the Commission conducts approximately, it can be 3 to 5 cases in formal proceedings, which go the full length in terms of the evidentiary hearing. And at that point, the commission has all sanctions, as well as it could always close the matter, available.
We'll go to the next individual. State your name in the microphone. Thank you for your testimony. At this point, I'm going to ask the commission if they would like to respond to any of the concerns that were brought up before us.
I would.
And if you can keep that brief, and then we'll go to questions.
There's rather a lengthy list of comments regarding particularly the statistical evidence that was presented to you. First, I'd like to say that a majority of the Commission's members are citizens, are not judges or lawyers, and that was by design with the 1994 constitutional amendment. At that time, it was also determined that the point at which proceedings should become public is when there's a public notice of formal proceedings. As to whether to get rid of confidentiality, there is certainly an impact on complainants and people who provide as testimony as witnesses to the Commission who have an interest in confidentiality. It is not merely to protect judges. And the Supreme Court, both the California Supreme Court and the U.S. Supreme Court, have noted that that contains balancing different interests at different points, and that during an investigation, for example, the scale weighs in favor of maintaining confidentiality. Should there be an interest in eliminating private discipline, in opening proceedings, all of these would require a constitutional amendment, and they are worthy of debate and consideration. The Commission's willing to provide whatever input and information the legislature desires, but this is not something that can be done. Most of it can't be done without a constitutional amendment. And I would like to just briefly state that the information relied upon in terms of numbers of investigations, comparing New York and California and Texas, was entirely erroneous. The comparison to Arizona and the numbers of discipline, fully 1/4 of the discipline or the actions taken each year in Arizona involve giving advice, and their annual report says explicitly it's where there is no judicial misconduct found and that it is not discipline. Including that in their discipline, if you actually take that out, they have a lower disciplinary rate than California. Likewise, in the study and the ones that them were carried through doing cost comparisons per investigation, they did not credit the Commission for the preliminary workup that we do. And last year was 545 cases in addition to the full investigations, but they did credit Texas and New York for that. And so the numbers change enormously when apples are compared to apples and when all the data that should be compared is included. Likewise, the resignations with charges pending, the numbers that were used in the report in both New York and in Texas include the number of complaints that were closed because the judge resigned. All 21 of the resignations with charges pending in New York may have involved the same judge. In California, we only count them by judge. Comparing those and complaining that there's this great disparity merely betrays a misunderstanding about the statistics and the data that's being relied upon. The projections about the amount of time the Commission spends on each case ignore the fact that the Commission receives voluminous reports starting 2 weeks in advance of each meeting. So the fact is the Commission members who are not paid, 6 of whom are citizens, spend a considerable amount of time working and preparing for every meeting. Not sure where the report concluded that the Commission was part of the Judicial Council and that I was initially employed by the Judicial Council. Since its inception, the Commission has been an independent constitutional agency, and I've never been employed by the Judicial Council or the Administrative Office of the Courts. I could go on, but I suspect you...
Yeah,